Hi everyone. We're just going to get started with the first panel, which is entitled "Theorizing Revolution and Theorizing Law." I'm just briefly going to introduce our panelists and discussants, and then they are going to take the floor. Our panelists for this discussion are Professor Lama Abu-Odeh from the University of Georgetown University Law School. Her research interests include Islamic law and family law, which she has researched and published on. We also have Dr. Vidya Kumar, who's a lecturer in law at Birmingham University in the UK. Her research focuses on constitutional law, philosophy of law, and public international law. And we also have Raif Zreik, who is the academic co-director of the Minerva Center for the Humanities at Tel Aviv University, where he's also taught law. His research interests include political and legal theory, as well as citizenship and identity issues. Our two discussants for this panel are Professor Zumbansen from Osgoode Hall, whose research interests include economic governments and transnational law, and Ali Hammoudi, who's a first-year PhD student at Osgoode, whose research interests cover legal theory and post-colonial theory. So each panelist will have 20 minutes to deliver their remarks, and then the discussants will each have 5 minutes to respond to the panelists.
All right, so I want to thank the graduate students of Osgoode Law School for making this possible, and I'm certainly honored that my paper was the occasion that got them together and gave them this idea. The good news is I'm just going to simply read from that paper to lay out a semblance of a theory about the relationship between law and revolution. I think the task of this panel, which is theorizing, is something that's quite intricate, and I'm just not good enough to simply improvise theory by addressing you, so I'm just going to have to read, and that's what I will do, all right, if you'll let me. Okay, so the Egyptian revolution has proven to be a very legal one. For the longest time, it seems, the forces that came to the fore since the toppling of Mubarak in February 2011 were choosing law as the privileged form through which to bargain with each other. The density of the legal back and fro has been overwhelming. Constitutional amendments, supplementary declarations, laws, legislative amendments, military decrees, court trials, constitutional court decisions overturning laws passed, conflicting decisions from various courts, presidential decrees, emergency laws, annulled and then reclaimed in another form. In fact, so much so that to trace the historical unfolding of the Egyptian revolution, one would be wise to use the Gazette and the law reports as one's primary guide through the maze of events. It is hard to miss the fact that in the case of Egypt, no sooner the public space opened up for the political as an autonomous sphere, one that is only possible through genuine democratic practice, then that sphere became annexed by the legal. Ironically, just as the political forces turned to law and institutions to mediate between them and arbitrate their raging battles in the way legal institutions can be expected to do, the Egyptian judiciary left its chambers and marched onto the public space, turning itself into a public interlocutor, holding press conferences, appearing in TV talk shows, making statements to the foreign press, explicating, defending its decisions to the public, cajoling, threatening, asserting, seemingly participating directly in the political argument apace in Egypt since the event of the revolution, sometimes openly privileging one side over the other. So while the political forces legalized their bargaining maneuvers, the judiciary politicized its role, so that whatever cover of law the political forces sought to acquire from the judiciary seemed to refuse to grant it, as if by denying itself the veneer of objectivity and neutrality, the public performance that sustains its high social status and privileges per judiciary, it has chosen to blow the cover of the political forces, call their bluff, so to speak. The public watched the national judiciary closely and longing for a just and revolutionary resolution of the political uncertainty and angst hanging over the skies of Egypt since the revolution like a stubborn, dark cloud, and which it had idealistically hoped law could clear, quickly surmised this was the corrupt judiciary of Mubarak, dependent, abject, self-interested, incompetent. Having failed to provide the revolutionary answer to the political stuckness of post-revolutionary Egypt, the judiciary quickly turned itself into the very cause for revolution. It was a bit more complicated, of course. The judiciary's performance had sufficient nuance, its failure to satisfy revolutionary desire in the law interspersed with some successes that some lawyers kept coming back knocking on the court's gates. Sometimes it seemed that what was driving litigants was not any faith in the courts themselves, rather an idealized rule of law state that they hoped would suddenly metamorphose before their eyes if only they kept the hope up and kept coming back. The legalization of political battles and the public scandal of the Egyptian judiciary's failure to return the revolutionary answer that the public longed for seemed to have turned every newly politicized Egyptian citizen into a lawyer. If the rule of law had to be out there, but the judiciary refused to pick it up, then by Jove, Ahmed and Adil were going to. And they were going to tell anyone who bothered to ask, and in legalistic terms, mind you, how the court had failed to rule legally, how it failed to take its own jurisdiction when it should have, how it took jurisdiction it shouldn't have, how it upheld the bad law about the military trials and overturned the good law about parliamentary elections. There's something very exciting about this popularization of legal talk, which one can see as a form of people taking law into their own hands, the layman demystifying the rule of the expert, and in-your-face busting a social hierarchy with all its concomitant privileges. Thus, in a very short period of time, one witnessed, in the case of Egypt, an interesting way of assimilating the limits of the rule of law state. Not through critique, as happens in the case of Western countries where the rule of law is thick, rather through an overturning of hierarchy, where every citizen becomes the judge and legal language is popularized, its technical mystifying quality flattened, made simple and accessible as it is digested by the lay mind. Was there something that the Egyptian judiciary could have done differently? Could it have carried the day and arbitrated the conflicts between the political forces in an objective and neutral manner as was expected of it? Could it have done it in a way that was persuasive to the contending parties and that allowed the judiciary to claim the mantle of autonomy and separation from the executive and the legislative? Many declined the behavior of the Egyptian judiciary as symptomatic of a pliant judiciary, a residue from the ancien regime, one that refuses to drop old habits. Many were persuaded that if the judiciary had behaved in a more autonomous fashion, the outcome of the legal battle would have looked altogether different, landing more squarely on the side of revolution. But this argument seems to ignore the fact that a judiciary that is available to act independently is one that has already been buffeted by a solid and robust political sphere, one whereby the political forces would not have felt compelled to legalize their primary political battles in the first place. In such a sphere, political forces bargain with each other politically, following the background rules of bargaining that are known to all, whether those rules were legal in the formal sense or merely customary. In other words, an independent judiciary is only possible when the judiciary intervenes to settle disputes among political players only marginally, and only when there is confusion either about the background rules of political bargaining in themselves, or a dispute about how to interpret the outcome of bargaining once it has taken place, even if each and every one of those cases has high stakes. In these cases, the judiciary, no matter how high the stakes, can intervene to shift the interpretation of the rules or change the political outcome by privileging one side over the other through its decision while still appearing objective and neutral. And can do all that while not appearing as if it were an actual participant in the political dispute. Of course, such conditions were far from prevalent under the dictatorship of Mubarak, where the judiciary as an institution was absorbed into the machinations of power of the ruling regime. There have been periods and instances where the judiciary fought the dictatorship. The High Administrative Court's anti-Mubarak rulings are famous. And the period of the 90s in the life of the Supreme Constitutional Court of Egypt, when the court took seriously the Bill of Rights in the Egyptian constitution and issued many rulings that pushed for more democratic representation of the system, is a period that excited many Egyptians. Overturning laws that cement repression or declaring illegal state actions that smacked of unfairness, abuse of authority, or corruption, and in the past 20 years there had been several of those, does indeed signal gestures of independence by the judiciary. But such acts of defiance against a background of dictatorial rule and interspersed with contrary acts of compliance by the same judiciary signal less a thick judicial sphere that is acting legally and more of a political sphere in which the judiciary is carefully calculating its position, counting its gains and losses, and basing its judicial interventions accordingly. Because the stakes are high for the judiciary itself, when it stands up in the face of a repressive regime, its discrete acts of opposition signal a deliberate political act of its own, as if underneath this veneer of upholding rightness and legality, it is acting no differently than the other political actors, using the tools available to it, law and legal discourse, to scurry in and out of the political scene. And since underneath the thin veneer of legality, there is a thick and overbearing political consideration, one loses the sense that what is being undertaken is a legal interpretive activity, a judge reading the law objectively and neutrally as the rule of law ideology would have him do. In other words, one might describe those acts as independent, but not exactly judicial, even though they are issuing from a judiciary and in the form of court decisions. What is gained in acts of independence by the judiciary is lost in the performance of a separate judicial sphere, because the element of calculation in the issued ruling is transparent when judged within the overall context of the behavior of the particular court over time. It is as if to be independent, the judge has to cease being a judge altogether. Something parallel to that happens in the collective mind of the judge's national audience. Contemptuous of the dictator's law and longing for justice and vindication from an alternate father, it turns to the judiciary for respite. Not much attention is paid to the laws themselves, to the nature of judicial activity. No interest in comprehending the machinations of interpretation. The judicial interpretive ethos that the judge sees himself as obeying, even if only on the surface of his consciousness, for the judge's audience, standing for becomes synonymous with adjudicating. Rightness and justice becomes synonymous with law. Thus, law loses its most basic quality, textuality, and judicial activity loses its most basic feature, interpretation. It doesn't matter how interpretively persuasive the judge in a given instance might be, as long as the decision doesn't correspond with the rightness and justice of the situation, the judge is not acting independently. So the audience might feel vindicated and rejoice with delight at the specter of an independent judge, the judge opposing the dictator, and the judge might savor the popularity, but what has been lost in this moment of joint elation is the idea of judiciary itself. It's not just when the judiciary is compliant that it ceases to be a judiciary in the proper sense. The same happens when it does exactly the opposite, when it acts independently. Now, new political forces have come to the fore as a result of the revolution in Egypt, especially Islamic ones, whose absence was notable during the time of the dictatorship. The loosening up of the political sphere should, on principle, allow judiciary room to maneuver, as it doesn't have to be beholden to one dominant dictatorial force, and could therefore avoid being absorbed in the political machinations of the time. At least such a possibility is open to an independently minded judiciary, which I will define here as, quote, inclined to be politically opposed to the trappings of dictatorial rule, which could conceivably emerge from the bosom of the present judiciary. After all, it is not uncommon to hear in Egypt, there is no independent judiciary here, the Egyptians say, though there are independent judges. But this born-again judiciary, after the revolution, finds itself confronting paradoxical and contradictory demands, which even if it were to call upon its most independently minded judges to meet, it's hard to see how it could possibly manage. It has to delineate the contours of the political sphere anew, while acting independently of it. And while it's at it, it has to perform interpretive fidelity to the legal materials as defined by the rule of law ideology, without which it cannot establish judicialness. And on top of all that, its decisions have to correspond to a revolutionary expectation of rightness and justice to make it all worthwhile in the end. Looked at more closely, two of those demands, judicialness and independence, belong to the rule of law ideology, while the third, rulings that correspond with rightness and justice, belong to the idea of revolution. This last one assumes that the judge's fidelity is to the ideas of rightness and justice, principles that mobilize the people on Tahrir Square. Whatever legal materials are before them, judges should interpret those materials in light of those principles. In other words, in order to comply with the principles, the judiciary has to immerse itself in the politics of revolution, forgo interpretive fidelity to the legal materials for the benefit of fidelity to principles. Rule of law and revolution, therefore, belong to two different logics that are in tension with each other, even though the one, rule of law, is often the historical genealogical descendant of the other, revolution. And even though, and here's the rub, the demand of the revolution has been the rule of law state. The logic of revolution. Arguably, revolution is the rule of law before the fall, or the Big Bang, if you like. It is when all the spheres are condensed in one, where their implosion has yet to occur as independent spheres, where the text has yet to separate from principle and acquire its maddening interpretive quality, where the rule of law state has yet to be birthed. At this conjoined moment, the screams on Tahrir, life, freedom, social justice, yield their meaning without textuality intervening between their intention and their words, when the revolutionary subject is there to inform us of what they mean, not in the sense that informing us is occurring orally rather than in a written fashion, although that too, rather that the enormity of the event in its earth-shattering transformation leaves no ambiguity as to what is desired. It is when all that is utopian is real. At that moment, law doesn't belong to the rule of law. It is something altogether different, as it is the simple working out in deductive fashion of the meaning of bread, freedom, and social justice. It is when deduction is most transparent, determinate, and necessary, made stable by revolutionary desire, that infuses the air. The revolution hovers as a meaning stabilizer, working as direct inspiration to law. Not only does revolution remove the barrier of textuality from its project of self-projection onto the future, it also dismantles all those other past texts that bedeviled its subjects with its sadistic indeterminacy used by power to stabilize their oppression. Law that is good combined with law that is bad, a civilian court with an emergency one, a democratically legislated law that is also a dictatorial one, text upon text in which legality as indeterminate textuality produced them determinately and always as criminals. The revolution as the set of principles that ends all text begins as a criminal act against the state, in which one's criminality in the eyes of the state and its law is rudely and fearlessly returned back to the state with j'accuse. The accuser, the state, becomes the accused, and the accused, the revolutionary, becomes the accuser. In this fashion, by staring the state in the eye, when she had always been stared down by the state, the revolutionary puts the state in its proper place. We all remember that famous lunge on the bridge over the Nile, when the multitude lunged forward towards the riot police, stacked up with their latest riot gear supplied by the good offices of the United States. And much to their surprise and everybody else watching, the police bolted back in fear. At that moment, the state, with its towering authority, crumbled, and the alienated powers of the collective projected onto the state were returned back to their original owners with a vengeance so sweet history had to record. Indeed, after that bolt, the rest was history. The revolution is therefore doubly an outlaw, a law that is out there. It eliminates the legal text of the state, it puts in its proper place, and it reduces law into principle, eliminating the textuality that typically haunts the gap between law and principle in situations that are not revolutionary. The logic of the rule of law. Law is politico-phobic within the rule of law. Its utopianism lies in its insistence on a clean and clear separation from the political. For the subject of the rule of law, the judiciary, the revolution smacks of the sphere of the political, where the messiness and ambiguity of power and resistance take place. It therefore cares not for a revolution as an event in new time, only what revolution has managed to pass in legislative texts. The universals of revolution yield no definite answer the judiciary wishes to read. What principles revolution may have enunciated have turned into legal rules, and that is the stuff of the rule of law. And even though the legal rules are framed in the shape of universals, generalities addressing all, the equality of the rules is only formal. Rules, whatever their content might be, apply equally to all, no exception. The equality opened up by the universals of the revolution are, on the other hand, deep and cut through the formal flesh straight to the substance of the bone. They are an invitation to, quote, bread, liberty, and justice to all, no exception. And while revolution challenges the authority of the state by putting it in its proper place so that revolutionary subjects can take back whatever power they have projected onto it, the rule of law puts the power back in the state. Unlike revolution, it is invested in exaggerating the power of the state because it speaks with the authority of the state outside of which it yields no meaning. Indeed, it affirmatively uses the power of the state to sanction and punish. And unlike revolution, that presages a clarity of meaning of what the subject of the revolution wants, the rule of law relies on written legal text created through legislative compromise. Ambiguity, gaps, and conflicts are inherent to the text, and interpretation, with all its frustrating pursuit of the, quote, intent of the legislature, is what haunts the subject of the rule of law. If all went well with the revolution, the common wisdom in Egypt says, the transition from revolution to rule of law would have been smooth, with the demands of revolution embodied in new legislative text and an honest, independent judiciary. So what puts Egypt as this conjunction of revolution and rule of law stuck right in the teasing middle. Its various contending parties using the rule of law to litigate revolution and revolution to put the rule of law on trial. Is the trouble with the Egyptian revolution itself that it did not yield a smooth transition? Perhaps one shouldn't call it a revolution after all. Is the trouble with the very notion of transition? The assumption that revolution yields a transition that is in effect an interruption in time and situation, and eventually yields new legal text and new judiciary? Or is the trouble with the idea of the rule of law itself the imagined respite it would deliver the revolutionary once it is in full bloom? So revolution, transition, rule of law is an expression of a time sequence that has captured the imagination of Egyptian revolutionaries. There's nothing unrealistic or rational about it. Put in simplest and most vulgar of terms, it is an expression of a perfectly legitimate desire to have a proper and functioning state. No sooner than revolution sizes up the power of the authoritarian state, showing the limits of its projected authority and the hollowness of its inside through its active resistance and challenge, then it seeks to seize the state, seize state power to prop it up again, this time on new terms, the terms of the rule of law. The trouble is that this time sequence, rational and realistic, is also highly indeterminate. The indeterminacy plagues each one of its terms, revolution, transition, rule of law, as events that are disruptive of time and situation. The indeterminacy of the first term, revolution, implicates the other two terms, making the whole sequence indeterminate. Do I still have time? No. Okay, I'll pick that up and hopefully in the Q&A session. Thank you.
Shall I go ahead? Yes. Oh, okay, thank you. Okay. In the break, I was asked what the topic of my talk, and I said I will talk about love. There's something about revolution reminding of love, in the sense that love and revolution, difficult to make them with cynicism and skepticism. And it's the nature and the role of intellectuals, following probably the first Kantian critique, is to know the limits of reason and the impossibility to know the thing in itself, and that we are always in the process of making question mark skepticism and raising question. So my talk is basically about skepticism and two kinds of skepticism and two kinds of the relation of law and revolution. The first skepticism, or the first relation between law and revolution, is kind of the law that leads to the revolution. The law not in the legal term, but the law in the sense, what are the laws of history that can lead to revolution, and is there are such laws? This is kind of a philosophy of history thesis. The other theme that I want to discuss is the law that comes after the revolution. In many ways, it's the new constitution and the new legal regime emerging after the revolution, and I want to raise skepticism about both. I have my own answers, but I keep them for myself. It's probably one of the insights of Hannah Arendt, and now let me address the more historical or philosophical skepticism about revolution. And it was probably Hannah Arendt in her book on the revolution that reminded us that revolution has the prefix re, and it's revolve. Revolve, it means it's a cosmic terminology about the stars, that they move in circles and go back to the same point, which stand in contrast and opposition to any idea of rupture, which we imagine with the revolution. So actually, the revolution is pretty much associated with law-like structure rather than with eruption or exceptionalism. There's a book by Kierkegaard called Repetition, and he says repetition is boring, everything lies in the exception, and actually most of Schmitt's ideas is drawn actually from that book on the exception. So let me pose then a few skepticisms about revolution, and let's try to think why we still have hope. One is overstructure. There are many overstructures theories. I want to dwell on Hegelian cunning of reason thesis that says actually history has a plan. It has a teleological plan, but and history is the site where reason unfolds, but we are humans, we hardly can discover that plan. History finds its way behind the back of its heroes. It uses the incentive, the desires, the aspiration of its heroes, but finally to get to its own games and its own ends. In this sense, it's not that we don't know what we are doing as subject, but simply we don't know what we do does. In the sense, how does it fit our action in the overall web? And we can never know that. When we act, we always act in a certain atmosphere of darkness, and only after dusk, when the Minerva spreads its wings and we turn on the light, we can tell what we were doing was doing to the overall structure. So this is the irony of history structure. And ask Gorbachev about his intention to rejuvenate socialism, ended up sort of reintroducing capitalism. Ask the American intervening in Iraq, and they ended up delivering it to the Iranian. Ask the Israelis creating or helping create Hamas, ending Hamas, their bitter enemy. And probably ask the young liberals in Tahrir, bringing the Islamists to power. This is a very cynical picture, and not because history doesn't have a plan, it does, but we can never penetrate the mind of history nor the mind of God. The other, and here probably this approach doesn't leave much space for an agency theory, and doesn't have a theory of revolution. We can endorse the revolution ex post factum, because if 2 and 2 are 4 with or without me, as the protagonist in the notes from the underground, Dostoevsky's novel says, if 2 and 2 are 4 with or without me, what's left for me? There are 4 with or without me, and I can't do much about it. The other skepticism coming anti-necessitarian historicism. And here it looks like that law is a collection of catastrophes, events, bad luck, good luck, and we can't do much about it. But here this theory might appear as a theory that leaves everything up for grab to us, and that we can mold history according to our imagination, our desires, and our aims, and our goals, because there's no structure, and everything is in our hand, everything is malleable. But on the other hand, if there's no structure, and there's no law-like structure to what we do, and there's no causality, how can we know that what we do can result in any difference in the world? Because we don't know what we do also does. In this sense, the lack of structure or law-like structures in history and society actually leave us very much hopeless, because we don't know that if there's a certain button that we press, then a certain events can happen. In this sense, actually, for an action to be meaningful, we need the structure in order for it to be meaningful, because it fits within a structure, within a narrative. If it doesn't fit within a narrative, there is no hope that we can make any change. So we are again reaching sort of a problem. Now, the hope might come from Marxism, because Marxism takes the Hegelian thesis of the cunning of reason, that history has a plot. But the Marxist story thinks that history has a plot, and all our previous generation were participants in a plot that they weren't aware that they were doing. So the bourgeois and the French Revolution, they're having a revolutionary role. They're writing history without being aware. So this is the cunning of reason story, except to the fact that me, Marx, when I appeared on the stage of history, from now on the proletariat is aware to its role, and this is the conscious part of history. Now, this is kind of seems like a combination of subjectivity and structure. Anyone who reads the Communist Manifesto reads the march of history there, and it seems that I'm just taking history to its ultimate end. It's just a march. There's law-like, and the proletariat, when it's become conscious of itself, it helps history to reach its own destination. And this looks like a very promising theory because it promises a certain combination of subjectivity and structure, and when they combine together, we overcome the shortcomings of the Hegelian and the anti-necessitarian. Probably Karl Popper here might come to mind, and we have a theory of a revolution. The problem is that most Marxist revolution, not all of them, were not practically promising, I must say, in the 20th century. So probably when theory offers hope, the praxis or the experience is a little bit more grim, let me say. But this is about what does it mean to act historically, or can we really make a change? Can you keep me updated? I have 10 minutes. Oh, that's great. I'm halfway there. Now, then, where does the hope might come from? I'm not going to answer this. Each one has his own hopes coming from somewhere. Now, let me move to the second theme. This is skepticism about making revolution. The second skepticism is about assuming that we're making revolution. What comes after the revolution as an event? And here are, I totally agree. I mean, the language of revolution for many of us who were Marxists in their 20s, we never imagined these days in the Egyptian revolution, where the revolution is absolutely being, the terminology dominating the revolution is rule of law categories. I mean, for most Marxists, it's emancipation, revolution of means of production. I mean, but let me say that there is something that makes the revolution imaginable in both the liberal and the Marxist tradition. And I want to raise skepticism about both in order to be able to think about where the hope is coming from after we do this skepticism. And I think that both, there's something in the Marxist tradition which is very clear. It's the idea of base and superstructure, and the idea that not every change is equal as other change, because there are changes that allow new horizons for changes, and change in the base is different from any change in the superstructure, because the key to history lies in the base. And it allows another kind of changes. It's open for a new horizons for a change. Now, I think there's a similar thing, and I don't know, I don't want to make far-reaching generalization, but I have to think about this more and to develop it more. But I think there's something similar in the liberal way of thinking, and so this is probably similar in both traditions, in modernity, and it's the idea that there are the basic distinction between the formative frame that we work within and the routine action that we do within the frame. So the multi-layered conception of our social universe. In Marxism, it's base and superstructure. In pretty much of the modern legal theory, it's the distinction about the two layers, two levels of making politics in Ackerman, it would be sort of the distinction between the constitutional moment or the higher politics, the historical politics, and the lower politics. In Kelsen, it's the distinction between the ground norm and other norms. Revolution is changing the ground norm, actually. The other norms are within the gravitational field of the ground norm. In Hartian legal terminology, there are rules, primary rules, which gives people rights and duties, and there are secondary rules. Secondary rules deal with the primary rules. They are rules about rules, how we make rules, how we identify rules, and how we change rules. And to make a revolutionary change, you make a change in the secondary rules, rules about rules. I take Hoffeld theory as also have this double structure. So we have rights and obligation at the first level. He doesn't use this, the idea of levels, but this is my reading. But there you have immunity and power, and immunity and power is those kind of legal categories actually that can reorganize the first level, which are rights and duties. So there is a correlation between the Hoffeldian structure of legal theory and HLA Hart structure of primary rules and second. And I think the idea of the revolution becomes possible when we start to think that of the multi-layered structure of the social political imagination. When it's captured by the idea of the double structure, we can think that there are certain changes that are different from other changes, qualitatively different, because they open the horizons for a new other changes. Now, and in this sense, probably this is in itself doesn't make a revolution in the political sense. It might make a revolution in other senses. For a revolution in the political sense, I think we need not only radical, profound changes, but with rupture, but usually many things that revolution needs to be thought as made by the people, by the masses. And I think we have to keep these three elements of revolution to be able to rethink them separately: rupture, radical, and the people making them. I think you can have sometimes radical change with rupture without the people. I think the Turkish example is by Ataturk is rupture with radical without the people. And sometimes you can, I said enough about this. Just keep in mind that these are three not necessarily coincide into each other. Now, the question here is, if we take critical theory seriously, we first took skepticism and philosophy of history. Now, if we take critical legal theory seriously, and that means that the persistence of ambiguities, gaps, indeterminacies in the system, that means that the possibility from moving from the higher structure to the lower structure is pretty much indeterminate. To say that we want a capitalist system, there are 100 ways to make it. To say that we want a free market, there's 200 ways to make it. To say that we have the rule of law, equality between in front of the law, there are 1,000 ways to make it. Now, if we take this idea of radical indeterminacy, or that the virus is going all the way down, then what does the difference between the forming context and the routine action of the everyday, the higher law and the everyday law, can mean if there is no way to move from up down, given this skepticism. Now, given this kind of skepticism, then the revolutionary is faced with the idea, then why do we revolution, and can we guarantee that the next day we can do, first of all, can we come to capture the site of power, which is the state and economy. And given that we managed to capture that, what might be the role of law in consolidating that achievement? Because it's all the way down that we face endless skepticisms, endless indeterminacies, and it's all the way down problematic. Then all the way up is skepticism, all the way down is skepticism, and how can you square the romantic fever of revolution with the skeptical sense of a critical theory? And in this sense, and this is where I started probably, as a reflection on my own experience as a romantic revolutionary and as a critical theorist, and like most intellectual project, like Hegel says about Kant, all philosophy is overcoming division, and all this paper is trying to reconcile two aspects of myself. Thank you.
So first, I'd like to thank our panelists for very interesting and thoughtful presentations, and hopefully I could do some justice to their ideas in about the 5 minutes or so. So I want to begin by addressing the limits of legal analysis with a quote by a well-known historian of the French Revolution, Georges Lefebvre, who wrote in his classic study of the Revolution, "The essential work of the Revolution of 1789 may be found registered in a Declaration of Rights of Man and the Citizen. But it would be childish to emphasize only these legislative enactments, throwing into the background the events which gave birth to them. Childish likewise, and indeed more so, to select from among these events certain ones to compose a legend. The old regime did not bend before the juridical revolution. Having taken to force, it was destroyed by force, which the people descending into the street put at the service of what they regarded as right." Lefebvre here is implying that one should not study a revolution solely from a legal perspective. The use of law as a lens in analyzing a revolution cannot disregard the socioeconomic, the political and social context underlying it. A narrow and purely legal analysis of any revolution would miss a great deal, as law alone is not what brings about revolutionary change, and surely isn't what brings down an entire political and social order. Of course, our panelists have done a good job in elucidating legal analyses of the revolutions by taking such a contextual approach. But I think one should still emphasize that the study of revolutions must necessarily be contextual. In this sense, therefore, the Egyptian revolution, for example, should not be seen as one that is merely a constitutional one. In other words, one should not accept the argument that some people, especially those in power in Egypt, want us to believe, which is that that Egypt has reached a constitutional moment or a legal crisis, and once this legal crisis is resolved, then the revolution has succeeded. This rhetoric of a legal or constitutional crisis tends to be used by counter-revolutionaries to prioritize the law or constitution over the revolutionary movement itself. Of course, as Professor Abu-Odeh mentioned, it is more than possible that the enemies of the revolution can gain power basing their legitimacy on the rule of law. And I would argue that law is generally used in this manner to slow down revolutionary change. This is exactly what has happened in Egypt with the hasty approval of the Constitution in December. And also one could mention Law 96 that was passed in November, ironically entitled the Law on the Protection of the Revolution. This broad law criminalizes political dissent by considering insulting and resisting the authorities and insulting the president as crimes against the revolution. And this is an example of how law could be used to further counter-revolution, ironically using the very language of revolution. With regards to the issue of legal skepticism, I would point out that the revolutionaries themselves are quite skeptical about the revolutionary process, especially when presented in legal transitional terms or as constitutional reform, for example. A friend of mine who was recently in Egypt and who has friends as revolutionaries and activists, when he came back from Egypt, I asked him, well, what do they think of the constitutional process? And he said that most of them actually don't really think of they're quite skeptical about the constitutional process in general and about the politics in general as well. But they think in the long term, so they're thinking of the long revolution. And for them, the revolution has opened up new spaces of resistance and struggle. And on the grassroots level, and this is where the real revolution is happening. In a sense, small revolutions are happening every day, whether it's through organizing workers or educating peasants. These revolutionaries do not have immediate hopes in a political process that marginalizes them. Their focus is on the long revolution, as mentioned, and this ties into the multi-layered change that Professor Zreik mentioned. The revolution continues in their view, whatever happens with the constitution. Professor Abu-Odeh suggests that the people were motivated by an idealized rule of law rather than a narrow textual conception of the rule of law. And she mentions as well the notion of justice. So I would argue that here one needs to put a focus on the notion of justice, and in particular revolutionary justice, as distinguished from justice through the courts. The French revolutionary Robespierre, who by the way was also a lawyer, said, "Peoples do not judge in the same way as courts of law. They do not hand down sentences, they throw thunderbolts, and this justice is worth just as much as that of the courts." Revolutionary justice is hence beyond the rule of law and beyond law itself. Professor Abu-Odeh refers to the revolution itself as both law that is out there and outlaw. In other words, law that is not law. Law that is spontaneous, immediate, not determined by textuality, and does not rely on past experience. This, I think, goes hand in hand with Robespierre's notion of revolutionary justice. It is not through the rule of law as interpreted in legal texts by the courts that the people intend to bring about change, but through revolutionary action and through their own collective agency. In that sense, the principles of revolutionary justice that guide the people are necessarily illegal and resistant to the rule of law. The hollowness of law and the legal text could only depoliticize the revolution, which in the end has certain political aspirations that require more than law to accomplish. So is it possible then for law to continuously be revolutionary and true to the politics of the revolution? Or do the principles underlying revolutionary justice disappear once one attempts to legislate them into law? These are the questions that we keep returning to in each of the presentations. And as was mentioned, there's a constant dialectical tension between law and revolution, and it may be difficult to come up with a satisfactory answer to these questions. However, I think that one should not confine the political aspirations of the revolution to the juridical realm, as there may be alternative ways to pursue the democratic politics of the revolution other than through law or the law. I would like to end by putting emphasis on the transformative potential of the revolution in reconceptualizing our understanding of the law. Professor Abu-Odeh has already mentioned, put emphasis on the manner in which law has been popularized and how the people have demystified it by appropriating it as their own. I would only add here that the word democracy wasn't the most common word in the chants of the revolutionaries, as the Western press wants us to believe. The most common words and references were ones that refer to the new Egypt, the new Egyptian, and as you recall the chant, "Hold your head up high, you are an Egyptian." I think this illustrates that the Egyptian people were not calling for a Western democracy or a Western conception of the rule of law, nor were they calling for an Islamic conception of the democracy or the rule of law. The Egyptian people were trying to conceive of something new, a new potentiality. They were attempting and are still attempting to create a new understanding of democracy and of law, something that, as Alain Badiou suggests, is unprecedented and previously unknown. Thanks.
Thank you very much. I go last, and then we have Q&A. Thanks for the opportunity. So all speakers, I think, have in common an uncompromising curiosity in law's role in an event, but maybe rather a process that claims singularity, rupture, discontinuation, and change, but whose place in an evolutionary process suggests an analysis that places revolution, in fact, in a narrative about past, present, and future, and acknowledges at the same time our, or really anybody's, inability to know how to get any assessment right in this context. These are dimensions of a context in which thinking about law and revolution takes place. But central to this recreation of, or acknowledgement of context, lies the question how we can in fact know what are the relevant facts that we should consider or what the irrelevant facts are, And very importantly, especially if we, and the question then is, who is the we who does this observation, look at events in different parts of the world, from which perspective we in fact look at these developments, and from which perspective and from whose perspective this distinction between relevant and irrelevant facts in fact takes place. So my impression is that a key connector between the present interest in law and revolution and the legal theory as such is in fact a question of knowledge. That is the epistemological basis of our assessment of law's role in, and as pointed out by our third speaker, in fact, after revolution. So a few comments very briefly about context, only to arrive at the end of these comments again at the question of knowledge and how to distinguish between relevant and irrelevant facts. And I'll speak about context in two frameworks. One is that the context of a debate such as ours today, of course, has to be seen in an ongoing conversation about the role of law vis-à-vis society, but also in investigation of what the definition, the working definition of revolution is in this context. Another part of this context is the very concrete context of a conference such as this one here at Osgood. And while that might be too local of a reference, but maybe it's helpful because some of the people that have been involved in this conference have also been involved in a reading exercise over the last few years. And 3 works that were on our reading list in that time was Tocqueville's Ancien Régime et la Révolution, Hannah Arendt's Human Condition, and then her book on revolution, of course, and then Saba Mahmoud's Politics of Piety. Now, question is how to make connections between these 3 books and what do they teach us. One is these books all talk about state transformation and assess the role of law in that context, but already by focusing on state transformation might already eclipse many other elements that we should be looking at. At the same time, the state transformation might help us to better understand from which perspective revolutionary events are in fact being theorized, but perhaps, as pointed out by Timothy Mitchell in his important work on colonizing Egypt, might already shape the entire process. Another focal point then is the aspiration of revolution, and the question then of what comes after the revolution and what is the revolution in fact supposed to achieve. And often the debates, especially one run against the development and the history of Western revolutions, has been about a choice between political emancipation and economic emancipation. Since Hannah Arendt's analysis in the early 1960s, there seems to be a choice to be made between these 2 options that are at stake. And already since Polanyi's critique of the disembeddedness of the market from an arguably political society, we know of the urgency of that problem. Now, the second context that we have to look at is that maybe we have to reconsider these backgrounds and those selections of readings, which is Tocqueville, Arendt, even Lefebvre, and a few others, to ask ourselves what might be a different perspective to be taken. So in my view, there is a growing awareness that maybe 2 dimensions of the political critique of law and its relationship to revolution are in fact quite dubious today. One is the very Western nation-state-based juxtaposition of political and economic emancipation, and in fact the framing of this tension between those 2 choices too often invisibilizes the relationship of the context in which these debates have been taking place, which is the North and the West, and the rest of the world on which much of this affluence and progress has come to depend. And the birth defect of much of this analysis, of course, has been pointed out, for example, by Sandhya Pahuya's book from last year, has been the disjuncture between a political and economic emancipation of many decolonized countries. Second dimension that has become quite dubious is the perspective from which these developments are being assessed, which is the question of the we, who in fact speaks about these developments. So now I need 1 or 2 more minutes. While this all points to the need to engage in a very comprehensive theoretical reflection, we all seem to be quite aware that maybe there is no time for such an exercise. So while the epistemological critique of Western or Eurocentrist frameworks continues, and we still attempt to decipher, for example, Chakrabarty's call to provincialize Europe, there's a growing concern today that the speed of developments stands in the way of an encompassing intellectual renewal. So when we go back to the question raised by our 3 speakers, we see how they can, in fact, and must be seen as to be in a continuing inquiry into the foundations of the attempts that were referred to by Hengame Sabri earlier, how to make justice desirable and love possible. We see that the question of the role of law in the revolutionary context is the variation, in fact, of the fundamental question about law's role in shaping emancipatory processes in society. Our task then is to use a critique of law as an instrument to study law's often blind involvement in processes that it understands so little but helps to push along in often frightening ways. Now, in fact, seems to be a good time to use law as critique, as illustrated by today's symposium, the 3 really wonderful papers, but also by intellectually ambitious projects such as the Twale movement or a poignant, detailed study of law and action such as Josie Raja's analysis of the rule of law and instrumentality in Singapore, or the renaissance of socio-legal scholars' collaboration with anthropologists and religious studies experts. Law is now again part of a truly interdisciplinary enterprise to analyze concrete conditions of political emancipation and human agency in post-autocratic democracies, but also in those societies that are too agnostic of the corpses in their basements.
Well, I just want to thank the panelists and the discussants for their really insightful comments and presentations. And we will now open the floor to questions. Just a note, if you have any direct or specific questions for Dr. Kumar, if you would please just hold off until the end of this, the Q&A session, and then she'd be happy to answer them for you at that time. But if there are any questions, now's the time.
Hi, I promised to ask a question. First, thank you all for the great, is this okay? Talks. I just have a question for both Professor Abu-Odeh and Professor Zreik about the Professor Abu-Odeh had mentioned, you mentioned in your talk, the trouble for the move from the revolution to the rule of law, as the rule of law, the secondary stage after the revolution, as sort of a trouble. And I was wondering whether perhaps that might not be a trouble, but that might be a good thing. I understand, of course, the way you see the rule of law is not in the way you've described, but particularly rule of law kind of acclaimed by the people and the activists, but still, you know, particularly that, and I would disagree with what you mentioned, that one of the main demands was rule of law, as you responded to Abu-Odeh, which was actually not the case. If anyone has seen the main slogans or the chants where bread, freedom, and social justice, it wasn't the rule of law. And in fact, there's a lot of uneasiness about the use of the legal system, and a lot of comfort about illegal acts during the revolution as it unfolds right now. So I was wondering whether you think perhaps that's a good thing, that we're not moving into the rule of law or legalizing the revolution. And as far as your talk, I just wanted to kind of point out, particularly by using that Marxist dialectical thought, is exactly the way in which we cannot use these old templates of revolution and apply them as they unfold right now, precisely by thinking dialectically that we can actually understand the truly unique character of what's happening in the Middle East without using the templates, you know, formulated much earlier. So I was wondering if you could comment on that.
Shall I start?
Yeah, it's all yours.
So thank you for the question. I might be misguided here, but I'm almost I've followed enough of the literature coming out of Egypt. The recurrence of the phrase "dawlat al-qanun," right? It really wasn't part of the slogans of Tahrir, but any discourse produced by the activists that's beyond the sloganeering, it very quickly pops up Dawlat al-Qanun, the rule of law state, right? And this then gets supported by two things that were very visible, that happened in Tunisia, happened also in Egypt, that very strongly suggest that Dawlat al-Qanun is a very, very strong demand, I would say, even as desirable as bread, justice, etc. And the first association in the minds of many activists of Dawlat al-Qanun is when the overturning of the security state, which is the state that the dictatorial, in the last phase of the authoritarian regime, both in Egypt and in Tunisia, has taken a very strong security state appearance, right? It's the last phase of the revolution, which meant that the control of the authoritarian system has ceased to be in any way functioning on an ideological level, i.e. very few people supported Mubarak. It was really taking place on a coercive level, utilizing the institutions of the security state. So for many of the revolutionaries, Dawlat al-Qanun was immediately understood as a negation of that, right? And they pinned hope on the idea of judiciaries and courts. So there's this one association. The other very strong association is you couldn't help but notice that they kept going to the courts. They just kept going to the courts, that the law intervened very, very quickly, and it was a puzzling phenomenon, especially in Egypt, right? Which, I mean, some people interpret it as the revolutionary side trying to make up for its political weakness on the ground vis-a-vis the Islamists, took its side to the courts and hoped that the courts would somehow promote them in the court system, right? But I actually think that Dawlat al-Qanun was on the minds of everyone as the anti-authoritarian state, as a negation of the authoritarian state. It was the political expression of the otherwise economic demands of social justice and freedom and bread. That was it, and it was going to happen through the rule of law. So I think I disagree with you about that. Yeah.
Hi, my question is for Professor Zreik. I wanted to ask about how you feel the trial of Hosni Mubarak fell within the skepticism, romanticism spectrum that you were talking about, the Hosni Mubarak's trial.
How?
Whether it was like a hopeful thing or if you see it in a skeptical way.
Yeah, it's pretty much not very much an event. Was the only good thing, I thought this is the first time that we can use the word what's it, the last president, and he's not dead. I mean, usually the previous president is dead. Suddenly we have a president that used to be president and he's not dead. That means I thought that this is a good thing to have, because usually the end of his life and the end of his political life coincide together, and suddenly we can see people continue to live after they continue to be presidents. This is the good thing. But it was clear already that there's a setback, that the revolution is not really going to its ultimate ends, whatever this ultimate ends that might be. If I understood that I'm hopeless, I'm not. I made 7,000 miles to come to speak. I'm not hopeless. I think one should be hopeful despite all the skepticism. But the question is where you bring this hope from. That's another question.
on the same note, I wanted to, it's a provocation to my friend Raif. So whether skepticism is a tenable position given the paradox of the skeptic, which is, can you be skeptic about your own skepticism? So in reference to Kelsen, which was referred to you by you and by Vidya. So Kelsen's idea, as the way I understand it, is that you have to be a believer in the basic norm. This is the only way in order to produce an authoritative order of norms or of legality. So the child asks his father, why should I go to school? The father says, because I say so. You say, why should I should follow your orders? He says, because God says that you need to follow parents. And then you say, if you say why I should follow God's orders, then you are not a believer in the norm. You are not a believer in morality, or you are not a believer in legality. So maybe the way out of this skepticism is just to be a believer in an unwarranted fashion that this whole mess in the Arab world will produce something good. Now, you have no rational way to ground that belief, but maybe this is the only way to do so. And maybe this is the way your Kant resolves the antinomy of free will and God by rational faith.
Actually, in the Kelsian sense, you don't have to believe in the ground norm. You have to presuppose the ground norm, and there is a difference between presupposing it and believing it. It's not a psychological event. It's not a matter of psychology for Kelsen. It's just that you can't think. It's pretty much, Kelsen is, as a new Kantian, is the condition of possibility of thinking law as a discipline. He's kind of thinking, the ground norm is the a priori condition of the possibility of thinking the legal sphere as an independent sphere, so you have to presuppose it. It's, in Kantian terms, we see that this is deduction. You go from what is already there and you go back. Now, the solution, the hope that you gave, actually, my own answer is part of a combination of Marxist and Kantian answer. The Kantian is, if you can't, as an antinomy, if you can't be confident that revolutions will work, at the same time, you're not confident that they will not work. So in this sense, the possibility of that you can make a change and you can't are balanced. And so what remains then, why to make it? And I think here's probably the answer is part Marxist, part existential, in the sense, dare you not? I mean, let me see if you don't, because we make revolutions, because in the process of making a revolution, first of all, we change ourselves. And second, and this is probably Sa'dallah Wannous, who's an Arab poet, he said, نحن محكومون بالأمل. We are condemned to have hope as a human being. And this is probably drawing again on Kant, but in another way. Kant starts the critique of pure reason saying, it's in the nature of a human reason to ask questions it knows it can never answer. And probably there's something about the human soul that it's continue its march toward its freedom, but there's no assurance that it can reach that freedom. But it become non-recognizable to itself if it stopped this sort of enthusiasm to reach that point, which it's not clear, and that there's no assurance that it would reach that point. So in a way, I do buy half of the Kantian rational faith.
Can I butt into this discussion? I very much like the Alain Badiou idea of faith. Alain Badiou has the idea that the revolutionary, by definition, has faith. That your faith, in other words, it's here. We're not assuming we are occupying the position of the intellectual. We are in a position of the revolutionary intellectual, i.e., the intellectual who is involved in the revolutionary process. What you produce, what you think about, leads and facilitates the revolutionary process. In other words, your faith comes from the fact that you are engaged in teasing out the revolutionary event to its, milking it to its very end. You're engaged, you're not commenting, you are part of the process, which is a truly Marxist idea, right? And I think if you do that, the only way you can do that is by having faith. I mean, that act presumes faith. Otherwise, you just would not be doing it. So, a revolutionary is a person with faith.
Those who, not from the underground, the protagonist there, one of the ways, and that's why I think there is a correlation between love and the revolution. The only moment that probably he's out of his skepticism is when he starts to fall in love. It's difficult to be cynical when you're falling in love. There's something about the moment of identification with what's happening that you can't be cynical about it. So in this sense, the way out is hope, love, and faith, if you want. So we're condemned to be faithful if you want to continue to act as political activists.
So if there's no other questions, I think.
After love, faith, and hope, what you can say?
That's true, nothing. There's nothing to say after that. Lunch, yes. So thank you again, panelists and discussants, and go outside.